Hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today in the series of Public International Law, let us learn a new topic, International Court of Justice. What is its constitution and jurisdiction? Let's get started. The International Court of Justice is one of the principal organs of United Nations. It is to function in accordance with the Statute of the International Court of Justice, which is a part of the Charter of the United Nations. The International Court of Justice is located at Hague, Netherlands. So, it is one of the principal organs of the United Nations and it is located at Hague, Netherlands. As the Statute of the International Court of Justice forms the integral part of United Nations Charter, all the members of the United Nations are ipso facto parties to the statute as stated in Article 93 Clause 1 of the Charter. So, who are the members of the United Nations are obviously becomes the parties if there is any dispute in the International Court of Justice. So, the members have the right to avail themselves of the services of the International Court of Justice and they also have duty to contribute its expenses. So, if in case there is an obligation of, if there is any breach in the contract between two parties of two different states, then they have, and if they are the part of United Nations, if they are the members of the United Nations, they can easily avail the services of the International Court of Justice. Each member undertakes to comply with the decisions of the International Court of Justice in case it is party to it. If such a party fails to comply with the judgment of the court, the opposite party can have recourse to the Security Council, which may then consider measures to give effect to the judgment as provided in Article 94 Clause 2. So simple. If two parties are there and if one party fails to comply with the judgment, then it also can apply to the Security Council for the recourse. So, and consider measures in the judgment can be taken place. So, this is the brief introduction regarding International Court of Justice. Constitution. The International Court of Justice consists of 15 judges with a president and a vice president elected by the members of the court amongst themselves. The judges of the court are elected by the Security Council and the General Assembly from amongst the candidates nominated by the national groups of the Permanent Court of Arbitration. The judges are elected regardless of their nationality from amongst the persons of high moral character who possess the requisite qualification in their country for appointment to the highest judicial office. Juries of the recognized competence in the international law are also qualified to be appointed as judges of the International Court of Justice. They were elected for 9 years and may be re-elected. The term of 1/3 of them at first election was 3 years and another 1/3 of them was 6 years. Thus, now 1/3 of the judges are elected every 3 years and no two judges will be from the same country. So, out of what is the constitution? Total 15 judges, one will be president, another will be vice president and remaining 13 are other judges, and these judges are elected every 3 years. 1/3 of the judges are elected every 3 years and they are elected for 9 years and may be re-elected. Jurisdiction. The jurisdiction of the International Court of Justice can be classified under 3 heads. They are voluntary jurisdiction, obligatory and advisory jurisdiction. What is voluntary jurisdiction? According to Article 36 Clause 1 of the statute, voluntary jurisdiction of the court comprises all cases which the parties refer to the court by agreement or mutual consent. It is the general principle of the international law that sovereign states cannot be compelled to take their disputes to the court without their own consent. The jurisdiction of the court therefore confined to cases voluntarily submit to it. This principle has in fact weakened the jurisdiction of the court. So, voluntary jurisdiction is nothing but if two parties have dispute, two different states have disputes among the treaty, then the states have to discuss among themselves with mutual agreement that we will apply it to the International Court of Justice voluntarily. Then this kind of ICJ is voluntary decision, which is the ICJ's decision is taken is voluntary jurisdiction. Obligatory jurisdiction. Article 36, Clause 2 provides that the states which are parties to the present statute may at any time declare that they recognize as compulsory ipso facto and without special agreement in relation to any other state accepting the same obligation. The jurisdiction of the court in all legal disputes arising out of interpretation of a treaty, any question of international law, the exercise of any fact which would constitute a breach of international obligation. The third is advisory jurisdiction. According to Article 96 of the UN Charter, the court may give advice on the points of law referred to it by the Security Council or the General Assembly of the United Nations, and the specialized agencies can also ask for legal advice of the court if authorized by the General Assembly to do so. So, in this advisory jurisdiction, the court can give advices to the nations, members of the nations, which the Security Council or the General Assembly refers to. So, we have three kinds of jurisdictions under ICJ. One is voluntary jurisdiction, obligatory jurisdiction, and advisory jurisdiction. So, among all these jurisdictions, what is the ICJ? What kind of law is applied by the court is given in Article 38. This Article 38 of the statute says that the International Court of Justice has to decide the disputes according to the international law. The court can apply international conventions, international customs as an evidence for the general practice. This general principle of law is recognized by the civilized nations and the judicial decisions and teachings of the great jurists. So, the ICJ should apply all these international conventions, customs, and the teachings of the jurists, and all these laws are recognized by the civilized nations. So, in this way, the ICJ applies law when the parties are in dispute.